We're going to talk about indigenous peoples' rights. And the case that we're going to focus on is the second of three cases decided by the Marshall Court in the early 19th century. The first of these cases, which is the subject of a different lecture, is Johnson versus McIntosh, decided in 1823. The second, and the one we're going to focus on now, is Cherokee Nation versus Georgia, decided in 1831. And the last is Worcester versus Georgia, decided in 1832, which will also be the subject of a separate lecture. Johnson versus McIntosh is important for present purposes for having established in American law something called the discovery doctrine. The case involved a land claim, a late British colonial era land claim. The land speculators lost, and part of the reason they lost, the court said, was that the tribes had nothing that they could sell to them because of the discovery doctrine. And this doctrine provided, as expressed in Johnson versus McIntosh, that upon discovery of the New World, the underlying title, fee title or radical title, some say, to all discovered lands vested instantly and automatically in the discovering European sovereign. So ownership of discovered lands, of the title to discovered lands, vested in the discovering European sovereign by operation of law in some sense. What remained to the tribes, to the indigenous peoples, was an occupancy right, later construed to mean essentially a right to occupy those lands and other things. And that occupancy right was alienable, could be transferred, given, or sold, but only to the same discovering sovereign, or someone who had that sovereign's permission to acquire it. Now, that rule was, I suggested in the other lecture and have said elsewhere, I believe to have been established in order to resolve a dispute unrelated to the Johnson versus McIntosh dispute, which was a dispute involving title to lands claimed by Virginia Revolutionary War militia veterans, lands in southwestern, claimed by these militia veterans to lands in southwestern Kentucky. That dispute disappeared after Johnson, and I think that John Marshall probably thought that the discovery doctrine would cease to have any real meaning, and it turned out he was wrong. And it turned out very quickly that he was really wrong. And it's important to understand Johnson versus McIntosh because it's Johnson that made possible the following two cases in the Marshall Trilogy, Cherokee Nation versus Georgia and Worcester versus Georgia. So how does Georgia get into this? Well, in 1802, Georgia had ceded its western land claims to the United States. This was something that Virginia had done earlier and North Carolina had done earlier and other states had as well. Georgia had charter claims, claims under British charters to the lands that became Mississippi and Alabama. And in 1802, Georgia finally said, okay, all right, all of those, whatever claims we have, whatever interest we have in those lands under these British charters, we're now transferring to the United States. And the U.S. established then territorial governments over those lands that were superintended by Congress. Now, Georgia's condition was that the U.S. would use its treaty power under the Constitution to come down to Georgia and make a deal with the tribal governments whose lands were within the claimed state limits of Georgia, under which those tribes would leave, would cede those lands up in treaties. They would then become the property of Georgia. Georgia could distribute them to Georgians, and the integrity of the state would be achieved. The tribes, Georgians weren't particularly interested in where they went. They could go west somewhere. 1802, it wasn't clear. It became clearer after the Louisiana Purchase in 1803 that, oh yeah, well, the federal government has lots of land or access to lots of land way out west. Maybe the tribes will trade lands in Georgia for lands out in the west. And the United States started to negotiate these treaties in satisfaction of its obligations under the 1802 Georgia Cession. The Muskogee Creeks eventually sort of agreed to move a little west. But the Cherokees didn't. The Cherokees, whose lands were in northwestern Georgia, said, we're going to stay. And the United States said, okay. And every few years, a Georgia delegation would show up in Washington, and whoever happened to be president would be asked, well, what about, Cherokees in 1802 and stuff? And the president would say, oh yeah, we talked to them, and they don't want to go. And we're not going to declare a war on them to force them to go. We'll go back and ask, give it a few years. But the Cherokees became less and less inclined to leave as time passed, or so it appeared, adopting a constitution. Sequoyah creates the syllabary. The nation becomes perhaps the most literate nation in the world at the time, almost overnight. A newspaper is established. The form of government has a legislative body and a judicial body, et cetera. And then gold is discovered in the Cherokee Nation. So they're never going to leave, Georgia decides. And in the late 1820s, the governor of Georgia and the legislature start looking at possible ways of changing the situation. What can we do to get these folks to leave? Because the pressure for land is only increasing for the Cherokee land. Someone discovered Johnson versus McIntosh at some point. It's a 5-year-old decision. It had been reported. It was available in the public. But someone took a look at that opinion and said, look, wait a minute. This opinion says that upon discovery of the New World, the discovering European sovereign instantly acquired title to the underlying indigenous lands. Well, that would have been Great Britain for the Cherokee lands, but then who declared independence in 1776? Answer, the individual colonies. So it was Georgia declared independence. Doesn't it mean that Georgia acquired the British Crown's ownership interest in the title to the Cherokee Nation's lands? And is there any indication that after that time, Georgia ceded that title to anyone? Answer, well, no. There wasn't any evidence that they had ceded it. And yeah, it sure looked like they had claimed to have inherited the underlying title claim of the British Crown, according to the Johnson versus McIntosh discovery rule. So what did that mean? Well, the way that the governor of Georgia saw it was if we own the underlying title and they have a legal right to occupy, then doesn't that sort of make us the landlord and they're the tenant? And if you've got a tenant you want to get rid of, isn't one of the ways, the most effective ways to do that by changing the terms of the lease? If you can't evict them, can't you change the terms of the lease? Like now it would be, I love having you as a tenant. You, of course, can stay as long as you want, but you can't have the dog anymore. And you're like, well, I've always had the dog. I don't want it. Well, I don't know what to say. You could leave, right? And so what Georgia does in 1828 is to pass a statute that says that effectively the Cherokees can stay as long as they want to, but from the beginning of June in 1830, they're going to be subject to Georgia laws. And their own laws will be of no value, and their lands are going to be divided up and attached to 4 Georgia counties. Now, they can stay, but that's the new lease deal. And if they don't want to stay, then they're going to have to find somewhere else to go. Now, the timing of this announcement isn't coincidental. It's deliberate. It's right after the presidential election in 1828 when it's become clear that we're going to have a new president, and it's Andrew Jackson. And Jackson, Georgia knows, is supportive of this idea of removing tribes, far more so than his predecessor, John Quincy Adams, would have been. And so Jackson's elected. He's not going to take office till March, but they go ahead and they issue this new piece of legislation. And of course, there's immediate reaction everywhere. Now, the reaction in Washington when Jackson takes office is enthusiastically supportive of what George has done. And Jackson appears before Congress and delivers his first annual address, and he says, look, here's what George has done, and here's what I think we should do, we the federal government, to support this. What George has done is right. They do have the power to impose their laws. The Cherokees are probably going to want to leave, and they shouldn't have a separate state within the bounds of an existing state, et cetera, because there are constitutional difficulties with that. But we've got lands that we've acquired from the French and from tribes out west. I encourage Congress to pass a statute that says to the Cherokees and other tribes, and other states have started to do this. Tennessee passed a law like Georgia's, and Alabama did. The federal legislation should say to these tribes, if you decide to leave because you don't want to be subject to the laws of the state, then we will make lands available to you out west. And they turned out to be, for the most part, in what would become the state of Oklahoma. So this is the substance of the statute that Congress does eventually pass, and it's called the Indian Removal Act. It doesn't oblige anybody to do anything. It simply says that if the tribes enter into treaties with the United States in which they agree to leave because they don't want to be subject to state law, then the U.S. will make lands available to them out west. Now, what's the Cherokee reaction to this? Well, not surprisingly, they aren't enthusiastically supportive of what George has done. They have a functioning government, they have a literate population, more literate than Georgia's, they have resources, they have a functioning economy. It happens to be an agricultural economy that's slave-based in the manner of the surrounding southern states, and they've got mineral resources, and they don't want to leave. So Georgia and the Cherokee Nation immediately come into conflict. Georgia starts attempting to enforce its laws. There are a few horrific cases. The most notorious is a case of a guy named George, his English name is George Tassels, who is he's Cherokee, accused of murdering another Cherokee in the Cherokee Nation, which would have been a problem for the Cherokees to address, but Georgia went ahead and sent folks in, arrested this guy, hauled him out of the nation, put him on trial for murder under Georgia law, and sentenced him to death. He tried to get relief from the Supreme Court, which sent word to Georgia to cut it out until the Supreme Court had evaluated whether they could do this, and the governor of Georgia effectively tore up the Supreme Court's note and said, nope, you have no jurisdiction here. And they hanged this guy on Christmas Eve. Now, that Tassels case could have become the test case, but the Cherokee Nation decided it would provide another test case. They weren't going to fight this out militarily, but they were going to challenge what Georgia had done, and they were going to do it through the federal judicial system, in which they felt more confidence than Congress at this point. So they hired a lawyer. Their principal lawyer was a guy named William Wirt, who had been for many years, through two separate presidential administrations, Attorney General of the United States. Wirt took the case. He was in the process of becoming a presidential candidate, and that had something, no doubt, to do with this. But he took the case along with a colleague, John Sargent. They were both very practiced Supreme Court advocates. And then they had to figure out exactly what sort of a suit they were going to file. They didn't want to go through the state court system because they didn't trust it, and they thought it would take too long. And they also didn't want to start at a federal district court because, again, the timing problem, and it'd be a local federal district court. What they wanted to do was to go straight to the Supreme Court of the United States, if there was any way to do that. And they looked at the Constitution and discovered that maybe there was. Because Article 3 gives the Supreme Court what's called original jurisdiction in a variety of cases. For instance, if a state of the union sues another state of the union, if Oklahoma sues Texas, that trial is conducted in the Supreme Court with witnesses and whatever you happen to have. This is called the exercise of original jurisdiction in the court. And there's another category of cases that Wirt thought might cover this suit, a suit by the Cherokee Nation against the state of Georgia. It's suits between states and foreign states. And so that's what Wirt fashioned. He put together a challenge to the legitimacy of Georgia's attempted imposition of its laws over the Cherokee Nation. He styled it Cherokee Nation versus Georgia. He filed it in Washington, and he claimed that the court had original jurisdiction because Georgia was a state and the Cherokee Nation was a foreign state. Why was it a foreign state? Wirt said, well, it's a state because it has a government, and it's foreign because 100% of its citizens are non-US citizens. And it's not a bad argument. But at the end of the day, it didn't succeed. Georgia didn't show at the argument of Cherokee Nation versus Georgia, which was held in early 1831. Wirt and Sargent showed, and they did the best they could on this issue. I think what eventually drove the court's decision was an anxiety on the part of some justices that if the Cherokees could file suit against a state, then so could every other tribe. And there were hundreds of them. And so I think there was a bit of a concern that the federal judicial, the Supreme Court, because these would be original jurisdiction cases, would become a court for the adjudication of tribal claims against states, primarily. Maybe that's what was going on. Some of the justices thought that the tribes simply weren't foreign nations. And others were, but others, a couple were okay. The way the opinions broke down is there is no majority opinion. There were 6 justices who participated in the decision of Cherokee Nation versus Georgia. 2 of them said the Cherokees are a foreign state for purposes of Article 3 original jurisdiction. Bring it on. 2 of them said they're neither foreign nor a state. And 2 of them, Chief Justice Marshall and Justice John McLean, said, well, they're a state, but they're not a foreign state. And that opinion, which Chief Justice Marshall authored, is the one that we think of as the Cherokee Nation versus Georgia opinion. On the merits, the Cherokees lose. There isn't jurisdiction because only 2 of 6 justices thought there was. But in the language of the Marshall opinion, there are 2 new ideas introduced that will become enormously important in the development of federal Indian law. In saying that the Cherokees aren't a foreign state or foreign nation, and Marshall uses those terms interchangeably, Marshall decided he'd better try and figure out what they actually were. So we get they're not a foreign state, but they are something, and they are a state, but they might be more properly denominated, and I'm quoting from the opinion now, a domestic dependent nation. A domestic dependent nation. And then he went on to say that their relationship to the United States resembles that of, and I'm quoting again, a ward to his guardian. Now, these 2 ideas, domestic dependent nationhood and the guardian-ward relationship, will become enormously important in future generations. But recognize that at the time, I think that Marshall simply put them in there not to create any new sort of legal regime, but simply to explain why he couldn't recognize them as a foreign state for purposes of granting the Cherokee Nation original jurisdiction in its lawsuit against Georgia. It's explanatory. It's not meant to be, in my judgment, in any way an attempt to create a new set of rights and responsibilities, although that's what's going to happen, as I say, in future generations. Now, the opinion closes, the Cherokees lose, but the opinion closes with an invitation. Chief Justice Marshall says, you know, we can't hear this case, but be aware that in a proper case with proper parties, we could. And that's the court's invitation to the Cherokee Nation to come back the next session with a better case jurisdictionally, at which point the court, Marshall suggests, will be ready to hear your complaint. Thank you.
Freedom 101 is made possible by generous support from the University of Oklahoma Alumni Association. Freedom 101 is a program of the Institute for the American Constitutional Heritage at the University of Oklahoma. For more videos and podcasts, visit freedom.ou.edu.